Before I actually proceed any further, just in terms of housekeeping, if you have any technical issues, please do raise them in the chat function. And in addition, if you have any questions and questions, please do also raise them in the actual chat function, and we hope to look at them at the end of this presentation. So, in terms of formalities, the first thing is the rules provide at CPR 32 and 33 rules relating to evidence. So this is where it's set out. But I should emphasize that that relates to the actual way in which the court manages the evidence that is presented to it. It doesn't relate to how, for example, a witness statement should be presented. And practice direction 32 and 33 support CPR 32 and 33. The only real relevance of CPR 32 is that at CPR 32.8, it basically says that a witness statement must comply with practice direction 32. I have mentioned in passing that you should also have regard to CPR 22, because that is a rule that says that certain documents, including witness statements, have to be certificated. And the reference to certificated is a reference to statement of truth. So moving to the practice direction, well, this is something you'll all be familiar with because we all do this. Practice direction 17 says that a witness statement has to be headed identifying the parties. So you're already all doing this, and it's simply the venue of the court, the claim number, and the name of the parties, whether they're claimant or defendant or applicant and respondent. However, some of the rules I think are honored more in their breach. For example, at 17.2, the rules require that parties should, sorry, I'm not sure what's happened here, bear me 1 second. Apologies for that. At practice direction 17.2, the rules require that witness statements should have on the top right-hand corner details of who the witness statement is made on behalf of, the initial and surname of the witness, the number of the statement, the identity of any exhibits or identifying any exhibits to be more accurate, the date of the statement, and the date of any translation. So in summary, for example, if there was a fictional case where I was preparing a statement on behalf of Clarke Willmott, what you'd have on the top right-hand corner would be witness statement on behalf of the claimant, witness, and then I'd put in my initial M and surname Mia. The number of the statement would be number 1, and then if it was exhibits, I would say MM1, and then the date of the statement. I can't actually recall the last time I had a document translated, but that would be up there as well. So this is information that should be on there, and to be honest, I think it's more honored in the breach. Practice is variable. Some people use it, some people don't, but I kind of find that I like to use it more often than not. The next thing that needs to be in the witness statement, and this is set out at practice direction 18, is, first of all, if practicable, it must be in the intended witness's own words. This isn't the first time that that is going to be said in the rules, and I will deal with it in more detail later. And again, most of the time, in fact, all of the time, we are all already doing this. The full name of the witness, his or her occupation, or if there isn't an occupation, a description. Generally speaking, I really only go as far as whether they're employed at that point or not, and then their place of residence, professional capacity, and workplace address, but also in what capacity they're giving the witness statement. For officers, it's usually on behalf of the claimant as the housing officers for them, for example, or if I was going to give a witness statement, I would be saying it on behalf of, for example, Clarke Willmott, and I'm employed as a solicitor, for example. The one that I haven't seen for some time, to be honest, is how the witness statement was obtained, for example, a face-to-face interview or over the telephone or through an interpreter. But again, that is something that should be in your witness statements. Sorry. Thank you. The next thing is that all the documents that you refer to in the witness statement, they should be verified and identified separately. In this case, you have an exhibit sheet. I would usually put in, I refer to paginated bundle of documents marked MM1, but it should be actually identified in a separate document, all the documents that are exhibited to your witness statement. And then the certificate. Since 6th April 2020, the actual statement of truth has changed and been expanded, and I have put down a full quote of what should be on your witness statements. Every witness statement needs to have that in, otherwise it, at worst case scenario, may not be admissible as evidence. There are also other certificates available for other scenarios, for example, where a witness cannot read, or for example, where the documents had to be translated. I provided a link below which can be cut and pasted to see the other alternatives that the civil procedure rules provide. Now, having set out the header and footer of the witness statement, for want of a better word, there's also the formatting of witness statements. In this case, these are the rules that should be followed in relation to the witness statement. First of all, A4 paper, which we're all doing, but also the margin should be about 3.5 centimeters. It goes to that detail. There's also fully legible, bound securely, pages numbered consecutively, and divided into numbered paragraphs. I'm going to pause there because I think it's important to emphasize that although I have seen this on occasion, but mainly in relation to particulars of claim or defenses, some people have occasionally used bullet paragraphs. For me, there's a practical reason to number all paragraphs, whether it's a paragraph number, a subparagraph, or sub-subparagraph. And the practical reason is that when I'm conducting a hearing, it is very easy to actually direct a judge towards a particular paragraph number. Whereas if you have bullet numbering system, bullet paragraphs, then you actually try to work out which bullet number point is that you're actually directing the judge towards. In addition, all items should be numbered that are numbered. For example, the date and figures, they should all be expressed as numbers. And then there's the additional reference to the fact that if you refer to any documents, they should be highlighted in bold. And finally, again, it's mentioned, witness's own language wherever possible. I will highlight that more further down in the slides. And finally, the signature. This, I think, is actually very useful in the current public health emergency, and that is that some witnesses do not necessarily have the ability to sign their documents and, for example, scan it back to us. But CPR 5.3 allows, allows documents to be signed electronically. And I have been using that recently because there are some witnesses who may be able to access the document via the internet, but apart from typing their name on it, they can't actually, for example, physically sign it and scan it back. So this has been very useful in that regard. So in terms of the actual basic formalities, on the top right-hand corner, I will put down the details of the statement. Here I've used a fictional situation where Clarke Willmott are issuing a claim against Joe Bloggs. And in this case, I've identified that I've identified that this is a witness statement on behalf of the claimant, Clarke Willmott, that I have made the witness statement, my initials and surname. And then there is my first statement and the date it's made and the exhibit that I refer to. And thereafter, again, we are doing all of these things, identifying the venue, the party's name, and then further down, I've also identified my position, my full name and my position, who I'm employed by, and also on whose behalf the witness statement is being made, in what capacity is what I meant there, sorry. And in this case, I'm making it on behalf of the claimant. In addition, I have also referenced the fact that there's some information which is to the best of my knowledge and belief, but other information I refer to in my statement, I will identify the source of that information. Really what we're getting at there is that if there's information that I do not personally have evidence of, I will identify the source of it. So in the case of a landlord statement, it might be a document, or it might actually be another witness passing that information to the person who's signing the witness statement. And finally, I always exhibit at the beginning a paginated exhibit marked, in this case, MM1, to which I will attach all the documents that I will refer to in the body of the statement. Then on the actual signature page where the certificate is, I also put in signed pursuant to CPR 5.3. What I should say in advance is that to date, whenever I've been taking statements from witnesses over the phone, I have also been asking them in advance about what arrangements they can make in relation to signing it. And if I know in advance that they can't print out the document, sign and scan it back to me, I will ask them if they can print their name, and then in that case, I will actually insert the phrase signed pursuant to CPR 5.3. To date, I've had no problems with the courts, and they have been happy with statements that have witnesses' names printed onto them and dated at the same time. And finally, there is an exhibit sheet to come with the witness statement if you refer to any documents. So that's basically the actual skeleton of a witness statement. And that's the building block for me from which I actually start preparing a witness statement. So in terms of drafting, the first thing to look at is, why do we need a witness statement at all? Well, the court says so is a simple answer, and it says so at Civil Procedure Rule 32.2. What it says is that the general rule is that any fact which needs to be proved by the evidence of witnesses is to be proved at trial by their oral evidence given in public, and at any other hearing by their written evidence. So that's the reason why we prepare witness statements. When a person gives evidence at trial, effectively what happens is that they'll be asked to, they'll be admitted to give evidence, and they'll be asked to confirm that that is their witness statement. So the importance of it is that they will still need a witness statement at trial to give evidence orally, because that's the document upon which they will be cross-examined by the other side. So what is the purpose of a witness statement? Well, I suppose the best way to put that is it's to present the evidence in a form that is calculated to be as persuasive as possible, as in you're telling the court to believe your version of events as opposed to the other side's version of events. And for me, I think the best way to put it is that it is telling a story, so I seek to set the scene. And what I'm trying to, I suppose, direct myself towards here is that although it is a very important document, it is still a story that I am conveying to the court about the circumstances of the particular case, in which case I will try and include all relevant evidence. But at the same time, the manner in which a statement is going to be prepared will be distinctly different for, say, an officer of a housing association as opposed to a tenant or a witness. So in terms of statements relating to antisocial behaviour, I think the starting point has to be that you need to have regard to what the Antisocial Behaviour Crime and Policing Act 2014 requires. What you need to establish under the Act is what will need to be put into your witness statement. But there's different requirements for what the landlord needs to establish and what the witness will need to establish. So there is a different perspective. In terms of antisocial behaviour, you will be familiar with most of these terms. For example, antisocial behaviour means conduct that has caused or is likely to cause harassment, alarm, or distress to any person. Conduct which is capable of causing nuisance or annoyance to a person in relation to that person's occupation of residential premises, or conduct capable of causing housing-related nuisance or annoyance to any person. The first two elements, they will be governed by what is reported to you, and usually you will know whether it falls within the meaning of those terms or not. But in terms of housing-related nuisance, that requires a bit more explanation. Housing-related nuisance or annoyance to any person. Well, housing-related is a reference to directly or indirectly relating to your housing management functions. So is quite wide. In fact, it's very wide. The threshold is not that high, but at the same time, it should not be taken for granted. So in your witness statement, I would be mentioning your housing management functions. So in terms of housing management functions, you have a considerable number of housing management functions. These are just some that I can think of off the top of my head. For example, organizing and coordination of repairs, communal cleaning, ground maintenance, carrying out stock assessments and work programs, collection and management of rent, home visits, gas and electricity safety checks, as well as the impact of antisocial behavior generally on the quality of your tenants. But what we're saying here is that in your witness statement, you should mention if the antisocial behavior is affecting your housing management functions. A simple example is, for example, if you have a flag on a particular property, that means that only 2 officers can attend at that particular property. It's already had an effect on your housing management functions. The fact that you cannot carry out repairs work safely because of the antisocial behavior, that has affected your housing management functions. So in your witness statement, I would mention the effect that the antisocial behavior is having on your housing management functions. If you're asking for a power of arrest, the first thing to understand is whether you meet the criteria of asking for a power of arrest. For example, in the Act itself, it says that the power of arrest is attached where the court thinks there's a use or threatened use of violence, or there is a significant risk of harm. So in that case, you will need in your witness statement to provide evidence as to whether the incident described falls into that category. Generally speaking, the description of the incident itself will be sufficient, and usually that is the case, but significant risk of harm is sometimes slightly harder to prove, but is still achievable. And in this case, there's also a definition under the Act itself, which says harm includes serious ill treatment or abuse, whether physical or not. The duty to consult. The first thing I want to emphasize here is that if you're making a without notice application, there is no actual duty to consult. However, what I have found out of nearly all the cases, possibly close to 100%, is that before a matter is referred to us, there is often some sort of consultation with the relevant body, for example, the police or the local authority. So I would actually put that in your statement. All I would say is that in relation to a without notice application, I would emphasize the fact that although there is no duty to consult, I have consulted with the relevant body. The other aspect of a duty to consult is that it's not a duty to ask permission from a third party as to whether you should seek the action you're seeking. What it is simply to let them know that you're going to take that action. So from our perspective, on a without notice injunction, if there has been consultation, I would certainly mention it in your statement, but what I wouldn't do is say that I'm duty bound to do it. So as I mentioned earlier, I would say that although there is no duty, I would then mention what we've done. But on the on-duty one, it may simply be sufficient to provide an email to say that you have consulted with a relevant body. On an application without notice, that means that your statement needs to be able to justify an application without notice. So you need to be able to show that there's threats of violence, or there is violence, or there's significant risk of harm. Again, this is usually quite straightforward because if witnesses are willing to come forward, it will be in their evidence. But in a statement on behalf of the landlord, you will need to be able to explain why you're seeking an application without notice. And the same goes with exclusion clauses. Sorry, I'll repeat that, exclusion clauses, because it's quite a draconian thing to ask for. So wherever possible in your statement, you should be emphasizing any additional information you can get to be able to get an exclusion clause. One of them is the exceptional risk that somebody may present to other residents on the estate or the area. The alternative is if, for example, the proposed defendant is not a tenant or has somewhere else to go. I would certainly mention that in your statement to increase the chances of getting an exclusion order. So in terms of the body of your statement, I think the most important thing to bear in mind is First of all, identify your relationship with the perpetrator, whether it's your tenant or it's a member of the family or it's somebody from outside. The second thing is to set the scene. For me, this is extremely important to do that because everything else will fit into place in terms of incidents of antisocial behavior. So, for example, I've set out a situation where the defendant is somebody who lives in a block of flats. I've gone into a little bit of detail to explain the environment in which the actual situation is occurring. Now, in terms of the incidents themselves, this can be slightly difficult because in recent cases that I've dealt with, often there's been a huge number of incidents occurring over a long period of time. In one instance, I think the witness suggested about 55 to 75 recordings of incidents. And depending on the type of action we're taking, I will vary the actual statement accordingly. So for the purposes of an injunction, what I will try and do is emphasize the recent incidents in detail, but mention some historical ones to indicate that it's been going on for some time. And indeed, when I've explained it to witnesses, they have been happy with that explanation. However, if, for example, the witness statement was for a possession claim, I might go into a bit more detail in relation to some incidents in the past, and then highlight the more recent ones as well. But I will pick and choose, I suppose, the most serious incidents. Then the next step is, and I think this is important to mention in your witness statement, is the effect on victims. Sometimes the victims may not be willing to come forward, so we do need to mention how it has affected them. The next aspect is the effect on your housing management functions. As I mentioned earlier, you have a whole host of services that you provide to your tenants and the locality in which the building is situated, and it will affect them. So mentioning how it's affected your housing management functions is quite important. Steps taken in relation to the defendant. Most of the time, in fact, nearly all the time, an Equality Act assessment has been carried out, but it's not always exhibited to your statement. I think it's a good idea to mention that it's been done and, if possible, exhibit it as well. It shows that you've had regard to the circumstances of the defendant before coming to your decision as to whether you should seek an injunction. In addition, there's also the particular circumstances of the perpetrator. In some recent cases that I've dealt with, I've had situations where they are particularly vulnerable. Nonetheless, we have still gone ahead with the injunction. For example, we've had situations where they're simply not engaging with us, or they're not engaging with any of the support services. If, for example, they're not engaging with you at all, and you don't know anything about the circumstances of the perpetrator, then I would certainly mention that as well. In terms of the duty to consult, again, that, as mentioned earlier, is relevant when you're making an on-notice application. But on a without notice application, I may also mention it because most of the time when a matter is referred to me, there has already been some sort of engagement with a third party, usually the police or the local authority. So I'm quite happy to mention it on a without notice application, even though it's not necessary on a without notice application. And finally, the justification for without notice, power of arrest, or exclusion. I think the best way I can put it is that a justification is when you're going for an injunction, the court is already thinking that that is going to be a draconian step. And then each additional and more intrusive term that you seek, the court will escalate in its mind what it considers more draconian. So if you're seeking an on-notice injunction, the court will consider that to be draconian. Then the next step up is if it's a without notice injunction, it will consider that to be more draconian. And then if you're seeking a power of arrest and exclusion order, again, more and more draconian. That does not mean that you won't get what you want. What it does mean is that you have to have evidence just to justify that step being taken. Most of the time, the incidents themselves will justify that step, but it's important to emphasize it in your statement that the action you're taking is justified by virtue of the incident. from a witness's perspective, it really does feel like you're telling a story, and they need to give evidence of what has actually happened to them in as much as possible their words and how it affected them. I've recently done quite a few witness statements, and some of the witnesses have come up with such phrases that I've actually directly quoted them. Recently, I had one witness who said that she was, quotation marks, shit scared. And I think it's important that witnesses use their words and the effect on them to come across to the judge. So I put that in the statement. Other occasions, I found witnesses are very reluctant to quote the actual swear words used. And I've emphasized to them that courts will want the actual words used. So in some instances, I've had to quote some very vulgar language. And in other instances, I've explained why, for example, the witness wasn't able to tell us what actually they heard. The example I can use recently is that the witness said to me that the person was nose to my face and was swearing, but I was so caught up in the moment and so kind of distressed and stressed and under pressure by it that I just can't recall the details of the incident apart from the fact that he was swearing loads, which makes sense. In a pressure situation like that, you may not recall everything, but again, at least it will be in the statement of the witness as to why they can't recall the specifics, but can recall the general nature of the incident. And ultimately, the actual incident will speak for itself. Now, in relation to statements relating to access, again, there's an emphasis here on the terms of your tenancy agreement. Generally speaking, most modern tenancy agreements will have a clause that relates to access. In your statement, I will definitely add that in there. In addition, I will also refer to your rights of access under Section 11(6) of the Landlord and Tenant Act, 1985. The reason I mention your policy and procedure is that from experience, what I've seen is, especially when it comes to the procedure, it will set out in detail the steps you will be taking. For example, I think one housing association initially gets the contractors to send out 2 letters to the actual tenant and also sends text messages to arrange appointments. And when those fail, it's then referred to the landlord, who then sends out at least 2 letters and also text messages and telephone calls. I would put all those steps into your witness statement to show all the steps taken to secure access. I would also exhibit the tenancy agreement and the letter to your witness statement in order to be able to establish that you've done everything reasonably possible to secure access. In some ways, the statement for access is possibly one that can be standardized more than, for example, the access injunction. So I would be guided by what your policy and procedure says in terms of the minimum and standardize your statement in that regard. Now, that's really everything that we can say about witness statements. But what I was going to say is the reason I added R at the end was simply put this. Sometimes there are so many facts that are coming from all different angles that it's actually extremely satisfying that when you prepare a statement to actually have one that puts everything into context. So that's the only reason I put that in. Now, in terms of the next stage, I'm just going to ask if you have any Q&As. Hello, I'm just going to check the question and answers that we have. And looking at the questions and answers, sorry, bear with me 1 second. There are quite a few.
Martha, I've written the 2 down from Katrina. They're the 2 questions that we have.
Right. Well, the first one is, I would say what I found, I think we've got a question here, is that you found that sometimes witness statements are sometimes so long, I could enter them into a Booker Prize. Is brevity best? For me, brevity is best. I think when it comes to witness statements, the difficulty is I'll use a recent example, I think is the best way of putting it. I was faced with a witness who had, I think, roughly 6 years worth of antisocial behavior. So in order to control the evidence, I emphasized to her the fact that I was not diminishing anything that she was saying, but as far as the court was concerned, they're going to be primarily concerned with recent incidents. So what I said to her was, even when you go to, for example, a possession claim, the court will say that choose your best 10 or best 15 incidents, and those are the incidents that we will have to prove at trial. So in terms of the witness, what I said was, I will emphasize that this has been going on for a long time. And luckily for me, in that particular case, it was lots of similar incidents, but repeated constantly. Effectively, the pattern was a huge, horrendous amount of noise nuisance going on for hours on end, involving shouting, screaming, and banging doors, etc. And I don't know how they didn't lose their voice doing that, but it was repeated. It would occur at least once, twice, or 3 times a week. So for me, in terms of brevity, what I would do is emphasize that this has been going on for about 5 to 6 years, that generally it is of one of these types, and at least once, twice, or 3 times a week. Where there's a change, I'll emphasize that by reference to those historic incidents, during another period, it changed to at least 2 or 3 times a period. So that way, I keep it short as possible so that I can focus on the recent incidents. And what I will do is I will go into detail about the recent incidents, and I'll pick 3 or 4 at most and go into detail. So for me, yes, I entirely agree. Brevity is the key. Emphasizing the history is important, but not, I was going to say war and peace on it. The detail is more important on the recent incidents. We have another question here. Sorry, the one other thing I would add is at the moment, because of the current public health emergency, I think the courts are being a bit more careful about the number of documents that they are considering. So what I am doing now is that when it comes to tenancy agreements, I'm not actually attaching them as exhibits. What I'm doing is that I am actually quoting the phrases and making it clear to the court that if it needs to have sight of the tenancy agreement, then that will be available should the court require it. Again, it shortens the statement down. In addition, I'm keeping exhibits to the absolute minimum as well. Once the public health emergency is over, we may have a bit more flexibility, but because we're having to send these statements via email, or that we're having to prepare a bundle that is then sent to the judge, and reading so much information off the screen is not necessarily that easy, to make sure I have the best possible chance of getting this order that I want, I am trying to minimize wherever I can so that it's easy to convey the actual facts of the case to the judge and get him on side, so to speak, or her for that matter. And can significant risk of harm for ex parte cover whether there's a risk of the victim's mental health getting worse because of the ASB? Yes, I think there is. And to be honest with you, I've actually made applications. I mean, I find myself putting myself in the position of the actual witness. And I keep thinking that if, for example, the noise nuisance has been going on from, I don't know, 11 o'clock in the evening till 5, 6 in the morning, the sheer effect on people's sleeping patterns and the knock-on effect on that on their health is considerable. And for me, I know personally that if I kind of lose sleep, then I get kind of headaches and so on the following day. But as witnesses, they are working, some of them, they're not able to carry out their work, they're not able to concentrate, they're completely and utterly tired, and it will affect their health. And if it's going on day end, in which case, one of my cases it is, then I think it is a significant risk of harm, and I'm certainly going to argue it. So in answer to that question, yes, I have been making some applications based on significant risk of harm, even though there's no actual threat of violence. I should also emphasize that I've been actually quite lucky because witnesses aren't always willing to come forward. And so in the cases that I have got, I have had witnesses who have been courageous enough to come forward, and I've been asking them to explain how they feel, and it's their words that I have directly quoted to pass the message across. So for example, I think one witness said to me that after these experiences of noise nuisance, she was teaching, and she felt at a point where she was going to break down and have a breakdown, and be close to tears. I put that in her statement because those were her words. I think it's so important, especially when it comes to antisocial behavior, to mention in the witness's own words how they feel, to get the message across to the judge that the incidents are having a significant and a risk on them, a significant risk and effect on them. So yes, I would absolutely try it, and if the facts justify it, I would bring it under a significant risk of harm. Now, I'm just looking to see if there are any other questions. Are there any other questions? What I was going to say is CPR 5.3, I've emphasized it before, but that's actually very, very useful in the sense that I have managed to get so many statements electronically signed, so that's definitely worth using, and I've had no problems whatsoever with the courts accepting that as evidence, although there will always be one judge who might take issue, but so far no issues whatsoever. So I'm now going to look to see if there's any other questions, but those are the only ones we have at the moment. I'm just going to scan to see if there's more. Kelly, do you have any other?
No, that's it, Muz.
I'll just wait a few more minutes to see if there's any other questions that anyone has, but I hope that's been helpful. Just so I'll just wait a few more minutes. But the other thing I could add is that we have found that we have been sending bundles of documents to the court, and if you're able or have a facility that allows documents to be bundled, what I've been doing is that I produced the N16A, the claim form, N16A, the draft order, and the draft power arrest wherever appropriate, plus the witness statements into a paginated bundle for the court to issue, because at the moment most of the hearings seem to be telephone hearings, and it just makes the document easier to manage as one PDF as opposed to multiple documents.
Muz, we have one more question.
Are anonymous witness statements effective? Yes, I think the weight attached to them can be, how should I put it, dependent on the judge. But again, I'll use an example that I dealt with where the best way I can put it was that when I spoke to the witness about the incident to my mind was so serious, and it was beyond the norm, because the impression I got of the defendant in this case was that he had the ability to cause a lot of danger and damage and hurt, basically, and was violent. And it was not the normal range of antisocial behavior. He was a very violent individual. And in that case, I got anonymous statements from the witness. I had them anonymized. I also had the officer's anonymized statements. And I made an application to the court to admit anonymous evidence, and the judge was happy with that. Had the matter gone further, then perhaps we would have had to have made arrangements to see if we could have video evidence presented, but it didn't go that far because the witness statements, the evidence, and the application were accepted on the without notice application, and on the return date hearing, the defendant turned up and didn't dispute the granting of the injunction. But anonymous evidence is very effective, and the only issue sometimes is how much weight to attach to it. But if you have a choice between anonymous evidence and no evidence, then I think I'd rather have some evidence from victims who are actually affected by antisocial behavior. And also the thing that needs to be borne in mind is the court do understand that there will be victims who are simply too scared to give evidence. Therefore, I think it's perfectly understandable to rely on anonymous statements. I'm just going to see if there's any more questions. Please do feel free to raise any questions or email us. I also should say that we have a hotline and a general email address that you can email for any questions, and we're happy to assist. And I'm just going to wait. Sorry, I'll go to the next page. I don't want you seeing my dodgy photo. I hope that was of assistance. I think for me, the most important thing to bear in mind is the law does change, but in terms of witness statements, and the basics are still as important. I think it is quite, what's the word I'm looking for, satisfying when you have a complicated set of facts and you're able to put them together in a simple statement. I also think that you should always look out for any statements that come across your desk, because everyone has a different style and you can constantly be evolving your skills in terms of the way other people draft their statements and see how they do it and adopt certain styles in your own. I am always constantly doing that, and I always look out for a nice turn of phrase that I might want to use in future. I don't think, yes, the question's been asked, can you please send slides? Of course, we will be sending those afterwards. I'm just going to check to see if there's any more questions. A recording as well. And what I will say is, thank you for joining me, and thank you for your time. I hope that was useful, and I look forward to hearing from you all in the future. So I'll be signing off now, and I hope you all have a great day. Take care.